Now you just crank it out, crank it out. With this litigation stuff, though, there's finesse because now you got these attorneys involved. The stakes are higher. You've got a lot of money on the line. And in some cases, the homeowners, the people who are in these units, they're suffering from these defects because it could be affecting their units. And so emotions are high. And you're kind of like this a balancing act between, I want to get to the bottom and the root cause of what is going on here. And I want to find the solution. But then they introduce this element of like, okay, but how do we allocate it? Like, who's at fault here? And is it an installation issue? Was it a design related issue? And you're pulled into these mediations and stuff, and you're trying to help them settle a case. And when that doesn't happen, you get pulled into depositions. And that's when I realized, okay, this is wildly different. You want to talk about a brand new animal. And I tell people that, this litigation work, if you're an engineer and you want to challenge yourself and you want to really test your mettle, like the Super Bowl's coming up. This is our Super Bowl. Like if you're going to go to trial as an expert, you are literally taking your license, your expertise, your experiences, and you're validating all the points and opinions in the case to support, whatever. So like if you're a plaintiff side, defendant, doesn't matter. But the cross-examination, and when you're sitting there and have an attorney trying to poke holes within your opinion and your methodologies and who you used and how you did your testing, it really tests the skills that you spent all these years developing. And you have to be able to communicate. And that's the other piece.